You two who showed up, and hello internet. This is the review for PLGL 30, review number 3. If you're here for geometry tests, we cannot help you. So let's go ahead and jump right in with, what is law? It's a good question to ask, especially if you're thinking of coming into a paralegal degree. It is a body of rules of conduct established and enforced by the controlling authority of society, aka the government makes the law. In some cases, if it's a theocracy, it's going to be a religious body who makes it, but for our purposes, our government makes the law. And we have an adversarial system. So that means that the parties of the lawsuit are opponents. And you present your case in the most favorable light, you win based on an application of the law, and an impartial decision maker chooses the outcome. So for us, turning Sean Connery, for us it's going to be a judge or a jury who is going to decide the outcome. Do you guys remember who's the person who's bringing the lawsuit, what they're called? Plaintiff, yeah. And who's the person who's getting sued? Defendant. I always remember it as the plaintiff complains and the defendant is defending. And those are what is the parties. We also have constitutional law. Now this means the text of the Constitution plus the court's interpretation of that text. For us, the U.S. Constitution is the supreme law of the land. Now this means they are federal. It is federal law. States also have constitutions, and so they're the supreme law of each state. Now, if it's an issue of federal law versus state law, do you guys know who wins? Yeah, federal is the one who trumps it. We also have, oh God, I know, right? Supersedes it. There you go. So we also have common law. Do you guys remember what common law is? Yeah. It's the body of law derived from the customs and judicial decisions of English courts. Now, English colonies are going to be most likely to have a system based on common law. So like the U.S. is an English colony. We have common law because, we got it from the dudes who came over. It's also a major source of U.S. law. So the judges base their decisions on earlier cases. Now, this doctrine is known as stare decisis. And wouldn't you know it, that's the next slide. Stare decisis means to stand by things decided. And it's a doctrine of precedent. Do you guys remember what precedent is? Yeah. Courts are obligated, so this doctrine of stare decisis says that courts are obligated to follow earlier decisions of past or higher courts. Now, what that means is they follow precedent. Precedent is, the difference between the two is precedent is the thing. It's decisions that furnish the authority for deciding later cases with similar facts, aka we decided this is a thing. And so then the next court that hears a case just like that is like, well, they decided this was a thing. So precedent is that act of making a decision that builds the precedent. Stare decisis is the doctrine. It's the sort of system that says, hey, you guys should follow precedent.
Yeah, it's important because it establishes the consistency in the law, so you're not just kind of jumping all over the place of what's being decided in this court versus this court versus this court. It's like everyone's deciding hopefully similar things.
Yeah.
They get challenged.
Yeah. We like things to be consistent and fair. All right, so when are courts going to depart from precedent? When are they going to say, hey, we don't want to listen to this? I'll give you a hint. The courts might decide it's wrong. The good example of this is Brown versus Board of Education. That went against the precedent of Plessy versus Ferguson. So Plessy versus Ferguson, not thinking off the top of your head, was that sort of Jim Crow era separate but equal, where courts decided that, hey, you can have separate facilities for people who are black versus people who are white because, as long as they're equal, it's fine. And then you got to Brown versus Board of Education, where they decided, hey, that was not cool. They were wrong. And they overturned it. They struck it down. They departed from that precedent. You also might have technological or societal changes that make it inappropriate. So, for example, there was a case called Smith v. Maryland in 1979 where they ruled that you had no reasonable expectation of privacy for information disclosed to third parties. Now, there have been a couple cases nowadays where they've said, hey, you need to depart from that precedent because, we put so much of our information onto phones. So think like, you log into Facebook, you log into Twitter, you shop on Amazon. All of these things have your information that they can sell to third parties. So because nobody could have predicted how much we use technology from 1979 to now, you could argue that they need to depart from that precedent because of technological changes. All right.
That's what they're fighting now, what Facebook is fighting.
It's a big thing going on right now. All right, so cast of characters. These are some, important parts of a lawsuit that you need to know. The parties are persons involved in a judicial action. So, you have your plaintiff, you have your defendant. They are the parties that are involved. Speaking of which, plaintiff is the person bringing a suit. A defendant is a person defending a suit. Again, the plaintiff complains. It's a fun little way to think of it. Now, an appellant is someone who's appealing the decision. And an appellee is a person against whom the appeal is filed. So, for example, I'm the plaintiff. You're the defendant. I'm suing you because you ran over my dog. Now, we go through the lawsuit. I win my suit. You decide, hey, I'm going to appeal this decision. I think the judge, violated a rule of law. I'm taking it up the next level. You would be, which one? Yeah, you'd be the appellant. I, the plaintiff, would then become the appellee. So, once you take it up that next level, the wordage can change around. So.
Not necessarily switch. The plaintiff could lose and then appeal and still and then become the appellant. It's just whoever files that next lawsuit is the appellant.
Yeah.
It could switch and it could not.
Yeah. So whoever is basically having the problem and wants a redo becomes the appellant. So it's pretty important to keep track of that stuff. If you're reading pleading, it might say Lindsay Gable, plaintiff and appellant, versus, Michael, defendant and appellee. I completely blanked on your last name. Or it might reverse. So, it's very important that you sort of understand which one is which, because it can come up later. And you don't want to be saying oh, I was appealing the decision if I wasn't, because, it can get complicated. As with most things with the law. All right. So then you have your judge. Judges can also be known as justices. If you think you'll have justices of the Supreme Court versus your everyday traffic court judge. When in doubt, call them a justice and then they'll correct you. But it seems if they're a justice, they don't want to just be like a judge. You don't want to be demoted. So it's important to know that they're both talking about the impartial person overseeing a trial. In some cases, the judge will be giving you a verdict if you don't have a jury trial going on. But, if you have a jury trial, then they're just there to make sure that, pardon me, that it's going the way it's supposed to go. All right. Standing to sue. Do you guys know what that means?
Seems obvious.
Right? It means you need sufficient stake in the controversy to justify a lawsuit. Meaning, if I'm going to sue you, I need to be, you got to have money in the game, so to speak. You need to have a reason that you're suing. So, like, if I were suing you for running over my dog, Michael couldn't be like, sweet, I'm going to sue you too. I'm going to get in on that. You know, you have to have a reason, because then the judge is going to be like, well, was it your dog too? And he's going to be like, nope. And the judge is going to be like, no, thank you. You need to have a reason. Now, usually that's going to be injury or threat of injury. So, you know, you ran over me, you've injured me. Or you came up to me and you were like, I hate your review sessions, I'm going to run over you in the parking lot. You know, that's a threat of injury. You need standing to sue to bring a suit. If you don't have standing to sue, it can get thrown out. Now, you can also sue on behalf of others. So, like, you know, in my instance of you ran over my dog, you know, I'd be suing on behalf of my dog. That gets a little tricky because dogs are technically property. Or like if you ran over my child. The child's a minor. Minors can't sue. So I'd be suing on behalf of that minor. But in that case, you still have standing to sue because, you know, your interests are vested in that person. Now, jurisdiction. Do you guys know what jurisdiction is? You're right there. It's the authority of the court to hear and decide a specific case. So you were like almost there. Courts have to have a jurisdiction before it can hear it. Now, there's a bunch of types, and we're going to go over all of these. There's in personam, or personal. There's in rem, which is in regards to property. There's subject matter jurisdiction, original, appellate, exclusive, and concurrent. So, like, this is our future for the next however many slides. In personam, aka personal jurisdiction. Courts have jurisdiction over residents of certain geographical areas. So California courts have jurisdiction over us because we're California residents. Los Angeles courts have jurisdiction over us because Mount Sac is in the county of Los Angeles. I'm pretty sure. I'm from San Bernardino, so I don't know.
I'm pretty sure that's right.
Now, you have things called the long-arm statute. This is where courts obtain jurisdiction over non-residents that have had minimum contact with the state. So, you're from Nevada. You come out here, you know, girls' weekend at the beach, and you hit somebody's car in Miami. Malibu, wrong state. Yeah. California, you've had minimum contact with the state. You came out here, maybe you rented a vehicle, you stayed the night in a hotel. You have what's called availed yourself of the state of California. Therefore, even though you're from Nevada, they can say, hey, the accident happened here, you came here, you've had minimum contact. That's why it's the long arm. We're gonna take and grab you from over here and bring you back over. So again, it's very visual, but you know, it's called the long arm statute because it's like yoink, and then they're taking you back over. It's how I always remember it. So there's also in rem jurisdiction. This is jurisdiction over property located in the boundaries of the state. So even if the people in the lawsuit are not from the state, they may still have in rem jurisdiction. So for example, say you're from Georgia and I'm from New York, and we decide we're gonna go halvesies and buy a summer house here in California. Neither of us are from this state, but the property in question is. So they would have in rem jurisdiction. They'd be able to say, hey, the property's here, the issue's here, you guys need to come here. You'll also have things called subject matter jurisdiction. This is where certain cases are held by specific courts. So I know you guys are having to memorize that good old court diagram. If you remember in district courts, you have the little offshoot of bankruptcy or IRS. Those are going to have subject matter jurisdiction. And it can be limited on the types of cases they can hear. So for example, only bankruptcy court is going to hear bankruptcy cases. They have jurisdiction over that subject matter. So I'm pretty sure you're not going to go into a bankruptcy court and be like, they murdered me! You know, they hear bankruptcy stuff. So that can, you know, affect where you're going to have your court case. Now, do you guys remember what original jurisdiction is?
Where the case began?
Yeah. It's the power of the court to take, try, and decide the case. It's who hears the case first. So these are going to be like your trial courts, both the state and the federal level. And they hear questions of fact. So your original jurisdiction, it's going to be, this is who was driving the car, this is where you're going to get a witness, this is where you're going to have testimony, that kind of thing. Versus appellate jurisdiction. Do you guys know what that one is?
You're gonna go make your appeal.
Exactly. It's the power of the court to hear and decide an appeal. So they're going to be reviewing it. You've had your original jurisdiction where it started. The appellate is, you've decided that you need to take it to the appeals court because it's a question of law. Now, do you guys want to venture a guess as to what's the difference between questions of fact versus questions of law?
Questions of fact could be whatever happened, and you're telling the story of what happened,
Mm-hmm.
and the law is what, I guess, was deciding it.
Yeah, very good. Questions of fact are going to be the facts of the case. Here's my witnesses, here's the defense, that kind of thing. Questions of law occur, and this is when you take it to the appeals court, of I, the defense, made a motion to throw that evidence out, and the judge denied my motion, and that evidence led to me being convicted. I'm appealing because, hey, they should have listened to my motion, and they should have thrown that evidence out. And because they didn't do that, I got a bad verdict. So it's not going to be, hey, I want to hear what Susan said because she lied on the stand. The courts in that case are going to be like, we'll take it back to trial court. But if you're like, hey, the judge shouldn't have let Susan talk, it's becomes issues of law, and were the courts following the right law? Were they ruling correctly? That kind of thing. Now, exclusive jurisdiction is, as you might imagine, they have the exclusive jurisdiction. They can only hear it. Can only be heard in a particular court. So, exclusive federal jurisdiction, again, if you remember your fun chart you have to memorize, are going to be federal crimes, bankruptcy court, patent issues, trademarks, copyrights, and suits against the United States. So if you're suing the U.S. government, you have to go to federal court. State exclusive jurisdiction is everything that's not federal or concurrent. So like family issues, traffic court, those kind of things that are really just affecting individual members of each state are going to them.
You just messed me up because I went this way, and you're going down this way.
All right, so concurrent jurisdiction. Do you guys remember what that one is?
You go either court, either state or federal.
Yeah. 2 different courts have the power to hear a case. Now, these are going to be federal questions or diversity of citizenship. So, federal questions. What ones are those? Mm-hmm. They are going to be U.S. constitutional issues, issues regarding Congress, or issues regarding treaties. If it's prohibition, for example, when they wanted to repeal prohibition, that was prohibition, the 16th, 18th Amendment? One of the amendments became an amendment.
It doesn't exist anymore.
Yeah. We don't need to remember it anymore, really. We do. We definitely do. Please remember it. Because it was a U.S. constitutional issue. It raised a federal question of whether this was right, and then they repealed it. So federal questions, they're going to apply federal law. Now, diversity of citizenship. Do you guys remember that one? It's going to be citizens of different states and over $75,000 in question. So
It exceeds 75.
it needs to be both of those, remember. So say I'm from New York, you're from California. I want to sue you, and I'm claiming diversity of citizenship, but it's only over like $500. Doesn't count. It has to be both different states and over $75,000. Now, we know federal questions apply federal law. What kind of law do you think a diversity of citizenship case applies? Yeah. It's going to apply the state law of whatever state you end up. Okay, venue. Do you guys remember what venue is?
It's the area, the place, the court.
Yeah, it's a lot of these, it's intuitive. Venue is the geographic district in which the action is tried and the jury is selected. So you need to choose the most appropriate location. If I run into your car out in the parking lot here in LA County, it's not going to make sense for me to try you in San Francisco. It happened here, we need to deal with it here. You can, however, request a change of venue if a party feels like they're not going to get a fair trial. So the example in your book is during the Oklahoma City bombings. The defense team of Timothy McVeigh, the guy who did it, were saying, we can't get a fair trial in Oklahoma City because everyone is biased against us. So they had to petition to get the venue changed. Okay, jurisdiction versus venue. Do you guys know what the difference is?
One's the authority and the other one is the geographic.
Exactly. Jurisdiction is, can we even listen to you guys? Are we allowed to even hear you? Venue is, okay, we can hear you. Where's it going down? Where can we hear you? So that's a quick difference between the two. All right, ADR. Do you guys remember what that stands for?
Yep.
Very good. Alternative dispute resolution. Why do you think we're going to want ADR? Why are courts pushing for that?
So you don't have to go to trial.
Yeah, that's a good one.
Cheaper, right?
Court trials are really hard to get. Why do you want to wait 2, 3, 4 years to actually have your trial start when you can do this, get it over with, and move on with your life, is the logic. Trials also cost time and money. It's expensive. And, it's great for us who are going into the legal profession because we're like, yeah, keep paying my salary. But you, the person, the normal average Joe who's trying to sue someone, you don't want to have to keep forking over all of those hours that the attorneys spend getting to trial. You want to just get it over with. It's also easier to bargain with the other side. Once you're at trial, it's like, no, we want to win. We want to prove our case. Versus you go alternative dispute resolution. You sit down with mediation. They're like, yeah, let's try and find a middle ground. Let's make sure everybody's happy here. And it keeps the courts moving. Again, the reason we have these huge, long wait times is because we're in California and people like to sue other people. So again, it means we're getting nice paychecks, but the courts really want to keep it moving. All right, so now we're going to move on to the opinions of the court. Everyone has them. Judges like to give them. So some of the opinions you need to know, if you're reading briefs or anything like that, are unanimous opinions, majority, plurality, concurrence, and dissent. And we're going to go over those right now. So, unanimous opinion. Everyone agrees. Hopefully I don't need to go into that too further. This is the, you hit a unanimous opinion and you're like, yes! I don't need to research further. I, don't need to worry someone's arguing against it. Everyone agrees. It's not really going to happen. So the majority opinion, do you guys know what that one is?
Yes. Say it's 4 to 6, the 6 is the majority.
Yeah. The majority is a judgment that gets more than half the votes. So on the Supreme Court, there's 9. 5 to 4 is a majority. 6 to 3 is a majority. 7 to 2 is a majority. 8 to 1 is a majority. It's whoever has the most votes. Now, a majority opinion is going to be written by a judge who holds it, meaning a judge who believes that majority opinion is the one that they want to go with is going to actually write it out. They're going to say, hey, we find that the defendant's guilty over running over your dog, and here's why, 5 pages later, because judges like to talk. It's going to state the outcome of the case and the reasoning for it. So, you're not going to get an opinion, I would not think, where a judge is just like, yeah, it's cool. Especially if it's in a case reporter, because that means it's gone to an appellate court or a Supreme Court. And so if it's gone all the way up to there, they're gonna want to talk about it.
Iraq, yes, yeah, it's cool.
Yeah. They're gonna be like, look, here's why we had to get all the way to the Supreme Court with this issue. Okay, plurality opinions. These are pretty dang rare, and they're where no one decision has over half the votes. So this could be like a 4-3-2 scenario, where 4 people say yes, 3 people say no, and then 2 people are like, maybe, or like, yes, but not for that reason. So it gets sort of fractured. You don't have that clear majority. So that means, if it's a 4-3-2, the 4s have it. Now in that case, it's probably going to be because there's a concurring opinion. Now this happens when a judge agrees with the outcome, but not the reasoning, and then writes an opinion saying why. So you can have judges concur with the majority opinion, where, say, Justice Mosk is like, here's what I feel, and then I'm sitting over here like, yeah, I agree with that. A concurring opinion might happen when I agree with the verdict, but not why. So the majority opinion says she's guilty of running over your dog because she was driving the car and it hit the dog and ran over it. Now I might have a concurring opinion saying, yeah, you're guilty of running over the dog, but not because you were in a car and ran over it, but because, I don't know what a concurring opinion would be for that example.
The dog ran under the car.
Yeah, the dog ran under the car, thank you, and you didn't swerve away.
Stop, but you didn't.
Yeah, so it's, I agree with what happened, but
Not for the same.
I want to put in my own 2 cents. I want to say, hey, I can't really say that's why I think it's this over here. So in that case, it's not going to affect the opinion. It's still the majority opinion says this happened, but it's a judge saying, hey, I want this other stuff on record.
So it won't affect the outcome.
No.
Yeah, because they're both agreeing to whatever it is.
I've generally found that justices write concurring opinions either because they think the decision goes too far or that they don't think it goes far enough.
Yeah. Now,
Basically.
a dissenting opinion is the opposite. One or more judges disagrees with the ruling. So this is where they think the outcome and the reasoning are both bad. So it might be, hey, I don't think they're guilty. I don't think they ran over the dog because the dog ran under the wheels of the car and they didn't swerve. Now, dissenting opinions also do not affect the outcome. Remember, the decision, if it was a 4-3, dissenting opinions would be those 3 who decided against it. They don't get to change it. However, it's usually a justice is like, hey, I don't want to go down in history on saying this was a right thing to do. I have opinions and you need to hear them. Now, dissenting opinions can be useful for persuasive arguments, and you can cite them as long as you make clear it's a dissent. So, for example, if you're trying to argue that someone should go against precedent, you can say, well, hey, in the case that set the precedent, these 3 justices argued against it. Here's what they said. So, if you don't have precedent on your side, dissenting opinions can really help with that. Again, as long as you make clear it's a dissent. You don't want to tell a judge, yeah, no, they rule against this. And then the judge is going to be like, no, you're wrong. We want to avoid having judges tell you you're wrong. Okay, so with that, we're going to go over the court system diagram. You definitely, don't blow this one off, because as soon as you get into 31 and legal writing, you're going to have another test where this is going to be right back on it. So, you need to know, and, you need to know this stuff because you have to know how the courts work, because we're going into law. Okay, so here's the blank diagram. I would recommend the way I studied it is I had the blank diagram on one half of a printout and the filled in one on the other. And I put it in a little binder sleeve kind of thing. So I tried to, like that. So I would write it out on the blank parts and then flip it over and see what I got wrong and what I got right. And so I just did that a bunch and a bunch and a bunch, and I remembered it. If you have different learning methods, I
Did
encourage.
a bunch of these.
Yeah. Yeah, if you have different learning methods, that's perfectly fine. That's just what worked for me. So, we're going to go over and fill this up together. So, I don't know if you want to
Yeah, I'll,
click or point.
I'll do it here.
Yeah. What's going to go in that one?
Original jurisdiction.
Yeah, original jurisdiction. All right, immediately to the right. How would you fill in that one? Yeah, this is going to be the trial courts. Which jurisdiction is the trial court?
The state.
Yeah, it's states. Very good. It's original jurisdiction. All right, what else goes in that
Oh, I'm
box?
sorry.
Civil, civil. No, that's the one. Limited.
Unlimited, limited, and small claims.
Yep. Unlimited, limited, small claims. Very good. All right, under that.
And everything else.
Like,
Family, auto, and et cetera.
et cetera.
Exclusive state jurisdiction.
I forgot.
Yeah, no, when you get it, it's literally going to be this blank diagram.
Okay.
And so you need to try, so don't leave anything blank. Try and fill in as much as you can. But if you can fill it in completely, obviously you want to try and do that. So, exclusive state jurisdiction, everything else, family auto, etc. Okay. Next, big box far right, that one, yeah. What's going to be there? U.S. District Court. Because remember, you're at the original jurisdiction level. On the left is state, on the right is federal. So, luckily for our system, it's pretty cookie cutter. You go up the same sort of paths, usually. All right, what are in those two little tiny boxes?
IRS and bankruptcy.
Yep, IRS and bankruptcy. All right,
Not Burger King.
Yeah.
Yeah.
not Burger King and IBM.
Yeah.
I did that one of the times I was practicing. I was like, no, that's wrong. All right, what's going to go in that box underneath district court?
Exclusive federal jurisdiction.
Yep. All right, what's in that one?
Oh, patent cases.
First it's IRS, then bankruptcy, then admiralty, and then federal crimes, then,
Patent.
no, that's the last one.
Well,
I like the more order around
yeah,
it, but there's a lot.
as long as you remember all what's in
It's
there.
probably- It's probably easier to remember them in the
Yeah.
order to do, yeah.
Mm-hmm. Yeah.
Trademark, yeah, and then
Yeah.
copyrights, copyrights.
So like obviously, you've got IRS and bankruptcy. Like, at least make sure you fill in those two.
Yeah, those two.
You know, get a point if nothing else. All right, what goes in that little tiny middle box? Or if you guys don't get that, if you miss it, I will be sad. You will make me sad. You will make your tutors cry. That's like easy points. All right, underneath that, what goes there? Concurrent. All right, what else is in there?
Questions, federal questions.
Mm-hmm.
Has to do with,
$25,000?
no, not yet,
No.
It's questions about the law, questions about.
Mm-hmm. Remember, we went over this earlier.
Yeah.
It's on the slides. But U.S. Constitution, U.S. laws, diversity of citizenship. Well, when is that one?
Citizens of other states, and then has to do with if it exceeds, if this
Mm-hmm.
case exceeds 75,000.
Yep. Different states, over 75K. All right, last box in the bottom section. Yeah.
Penalty, that goes straight to a.
Yep.
appeal.
Death penalties go straight to Supreme Court. Everybody else goes to, oh, sorry, top left box. What's up there?
Oh,
Appellate jurisdiction.
Yep. Remember when we went over jurisdictions, you have original at the bottom. Those are your trial courts. Regular trial court, U.S. District Court. Appellate jurisdiction is going to be your appeals court. So how many appeals courts do states and federals have?
six.
Well,
Oh, wait.
Sorry, that was a confusing question.
Yeah.
I'll give you the answer. You have two levels of appeals courts. You have
Okay, great.
the California, so we're going to say for California, you have your California Court of Appeals, and then you have the Supreme Court. The Supreme Court is an appeals court. It's part of the appellate jurisdiction. Because if you think about it, so say a death penalty case, you hear it in a trial, you're appealing it. You're appealing it all the way to the Supreme Court. Okay, so California Court of Appeals, what else goes in that box?
6 districts? And Los Angeles.
Yep.
Second district.
6 districts, LA is second. So I always think of it as LA, 2 letters, second district. I also tend to think of it as LA. We're not the best district, we're second. Like, you know. You gotta think of like little ways to get it in your head. All right, so California Supreme Court. What's in that one?
7 justices
Yep.
appointed by the governor. Oh wait, 12-year appointments. 12-year terms rather, and then they have to be reapproved by the voters.
Very good.
And none of them who know who the justices are.
Yeah.
I
So,
had to look it up. Just
The
like-
midterms we just had, we had to reapprove everybody. Or you had to say, no, get him out of here. 7 justices appointed by the governor, 12-year terms, reappointed by voters. All right, so going up from district court, what's in that box?
Federal questions. Oh, the little one, the little. bitty
No,
one?
the big box right above U.S. District Court.
This
Oh,
one.
okay.
Yeah.
The U.S. Court of Appeals.
Very good. U.S. Court of Appeals. What else is in that one?
It includes district and includes circuit and California's the 9th circuit.
So 13th, 9th
13th
Circuit. The running joke is people call California the 9th Circuit the 9th Circus because
That's in San Francisco.
we like to have all of the lawsuits. We're also considered the most liberal of the circuits. So a lot of people will try and make sure that their appeal gets heard here because, you know, we like to be.
You have to clear that one over there because we have to say that big long word.
Okay, very good. Okay, well, what goes in that box?
It has five, what are they saying?
So sure are.
Yeah.
Yeah.
Writ of certiorari.
There's 5.
Common parlance being writ of cert.
It's like
Yes.
a Harry Potter spell.
Yeah.
That's a rule of 6.
Mm-hmm.
No, yeah, the rule
Yeah.
of 6, 4 out of 6 have to.
4 out of 9 judges have to say yes. So,
And then the bottom one
yeah.
is there's 80 out of 8,000 petitions
Yep.
go up.
81 out of 8,000.
Mm-hmm.
So,
Oh, it's 81.
yeah. And we know California Supreme Court, you want to get over to the U.S. Supreme Courts, you have to have what? Federal questions. Yeah, so you have to petition for a writ of certiorari. You have to say, hey, Supreme Court, my case is special enough that you need to hear it. And I say special because obviously 81 out of 8,000, you know, you're not guaranteed to get your case before the Supreme Court.
Yeah, it's like what 1%?
Yeah, something even less than that, I think. You know, if only 3 out of the judges, or if none of the judges say yes, it's like, well, tough luck, friend, you tried. But
A friend of mine, his daughter, works in Washington D.C. She argued a court before the Supreme Court.
fun.
The case value.
Oh my gosh. That would be so terrifying. I'd be like, no thank you. Like, okay, so you get your writ of certiorari. Who are you going before?
Supreme Court.
U.S. Supreme Court. All right. What else is in there?
9 justices. Appointed by the president. Lifetime.
Yep, lifetime term. Appointed by president. So, you don't have to know them for this test, but you guys should really start memorizing who those justices are. Hint, hint, hint. There might be some extra credit questions in your future. And it's also very important for like you as future legal professionals to know who's in charge of essentially safeguarding the laws of our land. The Supreme Court is a very important place. It's very important in our legal justice system. So, you don't want to be like talking to someone and you're like, oh yeah, all those justices, Bob and Mary, and like I think there's a Ted. You want to know some last names. You want to know who's up there. Not in the least because it's a lifetime appointment. So, you would want to hope that they are qualified, and that is all I'll say about that. And so with that has been the review. Thank you, all three of you who showed up. Shame on you, internet peoples. I'm going to go ahead and turn this off now.